Before the lunch break, we had finished slide 109, which was completing that slide on negotiations on capitalization, and we're on the same topic at slide 110.
Okay.
So we were just closing now with some of Canada Council's correspondence with Ontario's council, Mr. Irving. Now it's the turn of Canada's council to brief his clients in the government of Canada about how the negotiations are going and what a settlement will look like. So Mr. Hogg briefs both J.M. Courtney, who's the Deputy Minister of Finance, and then William Fielding, who is the Minister of Finance, on this capitalization issue in June of 1899. To Courtney, the Deputy Minister of Finance, Mr. Hogg writes that, quote, "A more careful and thorough investigation of the number of Indians might result in a considerable reduction in the numbers shown in Mr. Scott's report," to which he has just got Ontario and Quebec to agree. But then Ontario has raised this issue of capitalization to say that if the amount to be capitalized is at a larger number, they are going to insist on re-examining the pay lists again.
Well, when you say he had just got them to agree, obviously they weren't sticking to their agreement because they raised it in the capitalization debate.
Yes.
Okay,
Said
sorry.
we would agree to these numbers if you give us the number we want on capitalization. Here,
They give and they take away.
Here, Mr. Hogg reveals what he thinks is a vulnerability on Canada's part, that if the pay lists were more thoroughly examined by Ontario, that there are many people on those pay lists who might be removed. And this sense of vulnerability, I think, has come through in some of the previous documents. Canada feels that they are potentially vulnerable on this point, and that it doesn't just affect Canada. Of course, it affects the people who are on the Robinson Treaty pay lists, not even to the extent of the payment on those pay lists, but on a number of other aspects of Indian status and the treaty benefits. So to the minister, Mr. Fielding, Hogg emphasized that any such investigation of the number of Indians would be a very tedious proceeding that could take a year or two to conclude. At this point, I think all of the parties are so thoroughly sick of all of these discussions on the accounts of the province of Canada, which hasn't been in existence for over 25 years, that they really want to get these accounts wrapped up and these negotiations concluded.
Slide 111.
So this is more of what Canada's council has told the Minister of Finance in June of 1899. Hogg informs Fielding that Ontario, quote, has expressed a desire through council that besides the ascertainment of the amount chargeable to the provinces of Ontario and Quebec under the arbitration proceedings, that the amount which is to be charged in the future, that is after 1892, with respect to these increased annuities, should also be determined, and that a final and complete closing of this question should be arrived at, so that no question in the future can be raised with respect to the increased annuities payable under these treaties. With regard to the Superior Treaty, no question whatsoever will arise for the future, as the balance of expenditure over revenue is such that there is no hope of any amount being available for the purpose of a payment of increased annuities. Therefore, the capitalization issue is only relevant to the Huron Treaty. So Mr. Fielding, the finance minister, approved Hogg's recommendation to settle for a lower capital amount with a higher assumed rate of interest in July of 1899.
Slide 112.
While Hogg is consulting with his clients in Canada, Mr. Irving is consulting with the Treasurer of Ontario regarding capitalization. He reports on some of these discussions. Irving does in a letter dated the 17th of August, 1899 to Mr. Hogg. And Irving writes that he's been asked what remains to be done to wind up the Province of Canada account and the Ontario account. In Irving's view, once the Robinson annuity claims on the old Province of Canada are settled, he thinks there is nothing to prevent those accounts being closed to the 31st of December, 1892. And that the Robinson Treaty charges are really the last items to be finalized in the Province of Canada account, and therefore the Ontario and Quebec accounts.
Ms. Jones, can we pull up this document you're referring to as you have the quote here for context, please? It's JBD 2714 and Compendium Demonstratives tab 155. Can you start by just confirming the document and how we should refer to it?
So this document was collected from the letter books of Emilius Irving. These are copies of letters that were sent from his office. There has been a question about the date, which I'll refer to perhaps in context of the reply. But this is a letter that he has written then to Mr. Hogg. In the last phases of the negotiations.
And can we infer from the title that it does concern both the Huron and Superior treaties?
Yes. If we can scroll down a little further. At this point, Irving is suggesting that Canada draft an order in council, which would be such as to enable the arbitrators to make a final award on the Huron and Superior treaties. And he is asking to see a copy, a draft copy of the order in council. This is an order in council, the basic content of which would be repeated, would be confirmed by Ontario and Quebec, Canada Order in Council. But then he goes on after this discussion of the technical points to ask, or to, I suppose, both to ask and to report to Hogg that what kind of conversations he has been having internally with the government of Ontario, the Treasurer of Ontario in particular. Irving goes on to ask, but I am asked Does the foregoing cover all the controversies? It is felt by our provincial treasurer that there have been occasions in the past when it was believed by him that all principles had been settled, and yet, nevertheless, some new question was raised. I am asked, have we got through these points? And also, does the Ontario account offer any difficulties which the accountants have in store to present? Because if not, it is desirable that some statement should be made to that effect. The Ontario government being most anxious to know, or to be able to forecast, or hope when this arbitration will be wound up. I think you can hear he steps outside of his official language type voice here to express the frustration of his client and possibly his own frustration about the length of time that some of these issues are taking to resolve, and also what is perceived as, I think, a shifting of the ground that has taken in the place in the past, where at the point at which an account is drawn up and items are added, then there are new claims, other items, different points brought up to be added to the accounts.
Can I ask you, Ms. Jones, up until now, we had heard that the Robinson Superior treaties weren't anticipated to be producing any revenues over expenditures for the foreseeable future, but the documents pertaining to both the Huron and the Superior treaties, can you tell us about that?
That the Superior treaties were not anticipated to be producing revenue in the future?
Yet they're reflected in this letter.
Yes, that this.
I'm sorry, that wasn't the question. It wasn't that they weren't, it was for the foreseeable future or something. I think it wasn't an absolute.
My question was, even though we've heard that there hadn't been any anticipated revenues over expenditures for the foreseeable future, can you tell us why they are now being reflected in this letter regarding a settlement?
Why they are being reflected?
Both the Huron and the Superior treaties.
Okay.
Communities.
It's included, of course, in the title of the letter. I think Irving here is passing on the questions from the provincial treasurer as to whether we finally have a comprehensive list of all of the items and the claims that are going to be addressed.
Inclusive of the Superior treaty annuities.
In a general settlement for the Huron and Superior annuity claims, as they have before them in this specific context, I might say, which is to settle accounts of the province of Canada. He does observe in this letter, Mr. Irving, that Quebec has some, and has raised in the past, some issues, for example, division of the income of the Common School Fund. And the Dominion has raised previously not known claims in the past, just as the Ontario has been under the impression that they were coming to a final settlement. We'll see Quebec still has some concerns about outstanding issues. The Common School Fund is one of them.
Unrelated to the treaty annuities.
Unrelated to the treaty annuities.
Slide 113 of the demonstratives.
The conclusion of this letter that we've just been looking at is a review of the settlement, the proposed settlement regarding capitalization. This is material that he's discussed with Mr. Hogg before then. Say there's going to be a capitalized sum taken to extinguish the annual charge of $8,200. for all future annuities and relief from all liability forever, the provinces of Ontario and Quebec from any further payment under the Huron and Superior Treaties of 1850. And that the whole debt of the late province thus ascertained on that day shall form part of the debt to be included in the amount of the whole debt of the late province of Canada, to be a portion divided and transferred in accordance with the award of the 3rd of September 1870 and the separate accounts of Ontario and Quebec. So this is going to be the outcome of this process. He wants a confirmation from Canada's council that this is going to be the settlement. There are notes in Irving's papers from this time period that record his understanding, quote, that the Dominion is willing to capitalize the $8,200 per annum on a 4% basis, and so giving up any prospect from Lake Superior or increase in numbers of Lake Huron Indians. In other words, they've come to numbers, they've come to charges on the Province of Canada account, which will be filtered through to the accounts of Ontario and Quebec in the appropriate proportions. And that is going to be the settlement, both for the past arrears and for capitalization of a future sum to cover increased annuities.
The 2714 was the letter from Mr. Irving. So when you say the notes, you're referring to JBD 3019.
3091,
Sorry, 91.
right. These are notes from his files on capitalization.
We can go to slide 114. Now we're into the orders in council themselves.
First of all, we have what Canada's response is to Ontario. The letter of Mr. Hogg on the 25th of August, 1899, refers to a letter from Irving of the 18th of August. Remember, I did say there was some confusion about the date, but the Hogg's letter here appears to me to be responsive to Irving's letter of the 17th. I've looked at Mr. Irving's letter books, and there are no letters between the 17th and the 22nd of August. So there is no other letter dated the 18th of August, 1899. You know, it's possible, we don't have, of course, Mr. Hogg's archives, so we don't know what the letter looked like when it reached Mr. Hogg, whether it had another date stamp or other identifier on it, or
Richard.
whether that's just a mistake. It's possible it's just a mistake.
But you're comfortable for the purpose of this slide that this letter you're taking us to now from Hogg is responsive to the letter we just looked at from Mr. Irving.
Yes.
And sorry, what do you say? Maybe it's just a mistake.
The letter that we just looked at from Mr. Irving's letter book
Yes.
has a date on it of the 17th. Mr. Hogg writes back to Irving saying, regarding your letter of the 18th of August, 1899.
Got it.
And again, I've looked at the original letter books, and there is no other letter between the 17th and the 22nd of August from Irving. So Hogg responds to Irving by saying he is going to prepare a draft order in council, as Irving has proposed, on capitalization, to extinguish the annual charge for all future payments of increased annuities under the two treaties of 1850. And this is, he refers to increased annuities under the two treaties, but the previous correspondence has led us to understand that capitalization is only being discussed for the Robinson-Huron Treaty. So I'm not quite sure why he refers to the two treaties, unless he means to imply that this is a global settlement for that for both Robinson treaties. And Mr. Hogg expresses his view that the arbitrators must deal with the question of payments made by the Dominion for increased annuities up to the end of 1892. That's going to go in an award. After 1892, it's Hogg's understanding that, as he says, the future after 1892 will, I understand, be finally and forever concluded by an agreement arrived at by orders in council of the three governments. Canada does issue an order in council on the 8th of December, 1899, which we can take a look at.
Over the slide to 115.
Bigger. So in this Canada order in council, there is a fair bit of the history of this whole discussion. Description of the treaties, that the claim is certain arrears of increased annuities and for money paid by the Dominion to these Indians from the year 1874, it says. I believe the first payments were made in 1875. That the amount of the fixed annuities was capitalized at Confederation. That amount was charged to the province of Canada. We can go further down. That capitalized amount has been paying the fixed annuities. That there has been no question in the arbitration about those annuities. But that in the year 1874, a claim was made that the lands were generating sufficient revenue to justify an increased payment. And thereafter, the Dominion has paid to each Indian $4. Then there's a description of the payments that are proposed to be made and the charges. Increased annuities from 1874 up to 1892. And the arrears of annuities prior to 1874, which haven't yet been paid. The amount to be charged to the province of Canada account on the Superior Treaty being this number $17,232, which is a number that Mr. Scott had come up with in February. The amount under the Huron treaties is given. This is said to close the account under these treaties in respect of the said increased annuities up to the 31st December 1892. And since the 31st of December 1892, the Dominion has continued to pay the increased annuities. The Indians will be entitled in future to receive and be paid such increased annuities. And then there's a discussion of the capitalization to cover increased annuities payable to the Indians under the terms of the said treaties. Therefore, a sum to be charged to the province of Canada account. And that after negotiations have taken place, the sum of $8,200 has been agreed upon as representing the amount which the provinces of Ontario and Quebec would be required to pay to the Dominion annually. This can be capitalized at $205,000 at a rate of 4%, which is going to be charged to the province of Canada account.
Could I just ask which trial exhibit you're referring to? There seem to be a couple on the page, on the slide deck.
We're on slide 115, Your Honor, and the reference joint book number is 2703.
So there's also a reference to 2559.
That's the number of the order in council.
Thank
Right. So if we could just look at the last text box up there. The one that's furthest to the right after the description of the payments. As part of this order in council, says it includes the claims of the Dominion on behalf of the said Indians for increased annuities. That the provinces of Ontario and Quebec,
Just by the way, this is completely indecipherable to me.
Oh.
So if you are reading from somewhere on it, please pinpoint exactly where you're reading from. So I'm at the last text box.
right,
If you're reading from there, and then where?
right from the top of that text box.
Claims of the Dominion.
Yes,
Okay, I thought you started with something else.
Sorry, I'm going to ask for some help again. Tab 2703 is in the compendium that has been provided to the court. The 5-volume set at tab 168 does not contain this document. So I don't know if council wants to clear up which document we're supposed to be looking at. That's all.
Please rely on the reference JBD tab number cited on the slide.
So it's
So-
not the one at tab
I
168?
I haven't paused to confirm one way or the other, but the tab inserted by Ms. Jones is JB tab 2703.
And so is the tab at tab 168 of the compendium. Yeah, maybe. I just don't know which one's right. One of them's obviously wrong.
May I have a moment, Your Honor?
Sure.
This is just a different portion. different-
Your Honor, the compendium of documents for the demonstratives is just extracts that are highlighted on the slide, and the larger document which contains the order in council is at JB tab 2703. So it's the whole document versus the extract that's causing the confusion.
All right. And is there, in the extract, can you direct me to those portions which are on slide 115 and or those portions which were just read by Ms. Jones?
I will do.
Although I fear pages are not numbered.
Well, you should only have the extracts that are relevant, which would be images 3 and 4. But let me take a look and then I will confirm for you. I'm being whispered that you should look at your tab 159 of your demonstratives.
159.
Yes. I'm not sure if that will clarify it for you.
Beautiful. Gotta be at least 1 point bigger in font.
it's tiny.
Ms. Jones might have a tool to offer.
I do. I have a weapon. If you want to use it. I
Don't know
Never
it.
am separated from my magnifying glass. But it is also, I have been finding that these documents are better in their digital format, and also they can be blown up to as big as you need.
Right.
The digital copies are at least one generation closer to the original scan, which can make a significant difference sometimes.
Well, when I'm at my desk, that will be helpful, but for the purpose of annotation. So I'm in tab 159, and if you can just direct me, and maybe this answers Mr. Schachter's question about what we were looking at. If you can just direct me what pages you were reading from, and I see that I have pages 4, 5, 6, and 7. Maybe I have it. Page 4. So the figures you referred to, Ms. Jones, there was,
Right.
I thought there was an 88,000.
The reference to the 88,000 is,
Do we want to go back to the slide? 115?
oops,
I see 95,000 as the figure
Oh,
for the
yes.
Hurons.
in this order in council, which sets out some of the history behind this whole dispute.
Yes.
Oh, I think it's up on the screen now. It's it's in the earlier part of the order in council, 1, 2, 3, 4 paragraphs, the 4th paragraph, which refers to the initial capitalization of what we've been calling the fixed or pre-augmented annuities. About which,
And
there-
possibly that's not in this extract.
No, it should be in there, Your Honor. I know you're looking at a different copy than what's on the screen, so I'm just going to pause because I want to make sure it's clarified for you.
Yes, please.
1 second, please.
I found it. Page 5. More than halfway down the page, that at Confederation in the settlement of the debts, that would be 1, 2, 4, 4th paragraph from the bottom. On page 5 of the extract at tab 159. It's page 5 of the document, is the actual award.
order in council. This is Canada Order in Council 2559. December 1899.
Actually, the document at tab 159 is the award of the arbitrators. And it's a publication of the Legislative Assembly of Ontario.
Right. This, I believe, was compilation. The orders in council are attached to the award.
Your Honor, can I assist? If you go to if you're on the first page of the tab, that's just the covering page, like Ms. Jones referenced, it's a compilation, but if you go to the second page,
Yes,
on the right side of that page,
yes,
I think it should say 5 on the top right corner.
yes.
And if you go down, it says 2559 underneath the verbiage name,
And that's the OIC 2559.
Ms. Jones.
Yes.
Got it.
These orders in council were attached to the 15th award. So I've used those copies here.
I think before we started to try to find the document, you were on the right column of the slide deck 115, which was you reviewing the top of the last few terms of the order in council.
Right.
I just lost all my screens. Did anybody else? Oh, there it is. Okay, thank you.
Right, so this carries over from the previous page, which has enumerated the amounts of money to be charged to the Province of Canada account. Described as claims of the Dominion on behalf of the said Indians for increased annuities under the said treaty. The provinces of Ontario and Quebec, as representing the late province of Canada, be from and after the 31st day of December 1892, relieved from all liability and further payment in respect of the said increased annuities, which may be payable under the said Huron and Superior treaties.
And can you just help me here? Under said treaty, is there a reference? Which treaty that is?
This is to the Robinson and Superior treaties.
Do you mean Huron and Superior Treaty?
Yes, Huron and Superior. That is a reference specifically to the capitalized amount of $205,000, which shall be taken to extinguish forever the annual charge of $8,200 for and in request of the annual claims of the Dominion for increased annuities.
Thank you.
Is there anything further you wanted to read from that page, Ms. Jones?
No, I don't think so.
We'd go to slide 116 then.
This is the Ontario Order in Council regarding the same settlement, which is, you can see, is quite a bit more condensed, quite a bit shorter. It refers only to the objective of carrying into effect the agreement which has been reached between the governments of the Dominion of Canada and the provinces of Ontario and Quebec as representing the late province of Canada. For the settlement of the amount payable in the past for increased annuities to the Indians under the Lake Huron and Superior treaties, and also the amount of capitalization thereof for the future.
Your Honor, if you're trying to find that in your compendium of demonstratives, it's tab 160.
160.
Yes.
Again, we have an enumeration of the payments, the charges that are going to be made and at what time.
Ms. Jones, do you want me to move on to the next slide?
No, I'm going to look at the last couple of paragraphs of this Ontario order in council. It's the capitalized sum again, which is to be charged to the said province of Canada account as of the 31st day of December 1892 and be taken to extinguish forever thereafter the annual charge of $8,200 for and in respect of the annual claims of the Dominion on behalf of the said Indians for increased annuities under the said treaties. And that the provinces of Ontario and Quebec, as representing the late province of Canada, shall be relieved from all liability and further payment in respect of the said increased annuities, which may be payable under the said Huron and Superior treaties. The last paragraph is the direction that it be apportioned between the separate accounts of Ontario and Quebec as directed by the award of the 3rd of September, 1870.
Are you content to go to slide 117?
Yes? Quebec also issued an order in council, which I have not reproduced here, but it was issued on the 10th of May, 1900. Again, there was a delay on Quebec's part because of concerns it had over an Ontario appeal to the Supreme Court regarding the division of the Common School Fund. But when the Supreme Court refused to hear the appeal, Quebec agreed to issue the order in council respecting the Robinson Treaty annuities, which is similar to that of Ontario's. So then a few weeks later, on the 2nd of June, 1900, there was a meeting of the arbitrators at which Hogg filed the orders in council of the three governments and asked for an award to be issued confirming the charges to be made to the accounts. Again, this is supposed to be the mandate of the arbitrators, is to settle these accounts and to decide on the charges. And Mr. Hogg introduced the material by stating that the parties, quote, have now agreed upon the amount to be charged to the province of Canada account for all future annuities under the treaties, so that it will be a final winding up of the Robinson Treaty case, not only for the past, but for the future. At a later part of the proceedings, where there was some discussion between the parties over whether a similar arrangement could be reached in the case of the Common School Fund, Mr. Irving then commented on the Robinson Treaty settlement that they had just presented to the arbitrators, stating that, quote, the Dominion have taken it for better or for worse. There should be no more squabbling as to your paying too many Indians or too few Indians and how much or how little. That was how he was describing the Robinson Treaty settlement.
Where did he make his discreet comment?
This is on page or image 58 of,
But what was it? What was it in?
it's the transcript of the proceedings
Oh,
of
is it
the
the
meeting of the
transcript?
arbitrators on the 2nd of June, 1900. So the same meeting after they the parties had just presented the arbitrators with their orders in council and the proposed settlement.
Thank you.
Over to slide 118.
Yes. This is more information from the transcript of the meeting of the arbitrators on the 2nd of June, 1900. At this meeting, Hogg filed, quote, for final disposition and confirmation, the Canada account, he means the province of Canada account, containing all the items which have been in dispute between the several governments and which have been referred by the Act of 1891 and by the reference in this matter for disposition and award to this tribunal. The arbitrator Casso asks if there is any further evidence to be submitted. And Hogg replies that there is no other item prior to the 31st of December, 92. And he does suggest, Mr. Hogg does, that of course it may be in making the award upon this account that your lordships would reserve or put in some clause in the award reserving items, any item which might arise after the 31st of December, 92, but which may have taken its origin under some statute or agreement prior to that time or prior to Confederation. And the one that he has particularly in mind, which has been an object of discussion among the parties up to this point, is something called the Yule Bridge, which is an instance of a bridge that was built under a contract signed prior to Confederation. The operators and builders of the bridge were to receive some tolls that to be charged on the bridge. And then at the end of the 50-year period, which was after Confederation, they were to have ownership of the bridge. And the descendants of the original Mr. Yule had been engaged in negotiations and some moves towards litigation on this particular case, the Yule Bridge case, it's called. So the a reservation clause was anticipated to deal with items such as this particular one. There were a couple of others, but the intent seems to be to address brand new items rather than to add on to or revise items that were already in the province of Canada account. Ontario files a province of Ontario account agreed to by Canada and Ontario at this same meeting. Go
Over
to
to
the
one-
next slide.
119.
Before you go there, is it your intention to ask the question if this opinion of yours with respect to Mr. Hogg's comment differs in some way from the view of Professor Messamore? I don't recall exactly her evidence on this point, but I know there was evidence on this point. I'm not sure if you're underscoring a
Well,
difference here.
I don't want to repeat Miss Jones's evidence she just gave, but she explained that she understood that the Yule Bridge and other items not accounted for was what that provision was intended to address.
Yes, I got that evidence. I'm just asking if you are highlighting that that is a difference.
It is. My
Okay, and
understanding is it
perhaps you
is.
could highlight what that difference is?
All right. Again, I don't necessarily wish to paraphrase what she wanted to say. But it was my impression that she was pointing to some of these without prejudice type of clauses to indicate that additional material or revised material under items that had already been agreed to in the accounts could be revisited or reopened. And in my reading of the evidence, there were some specific items which had not yet been added to the accounts that were the origin of those without prejudice clauses.
So you give a background to the origin of the clause, but you don't purport to say this is what it means, or
That's right.
this is what it can apply to or
That's
not
right.
apply to.
I'm looking at some of the contextual evidence around the references to that clause,
Okay,
how the parties referred to it and what else was happening at the time besides what was going on in the Robinson Treaty discussions.
all right, so we can call that, if you agree, contextual evidence with respect to that clause.
Yes.
And slide 119. Can you tell us what this image includes, please?
This is the 15th award, which was issued, excuse me, issued after the meeting of the arbitrators in June. If we can make this a little bigger. Yes, the 15th award, called the final award because there have been 2 previous awards on this subject. 1st of August, 1900. There is a preamble, which is common to most of the awards about the settlement of accounts between the Dominion of Canada and the provinces of Ontario and Quebec. And then if we could go on. The preamble includes the information that the claims of the Robinson treaties for increased annuities as a claim against the late province of Canada was to be heard by the arbitrators. And then if we could move on. That the parties have given that there has been a mutual agreement and arrangement which will appear by reference to the orders in council, which were attached, as we've seen, they were attached there. And then there is an enumeration of the charges as the 3 parties have agreed. First, for the Lake Superior Treaty, charges against the province of Ontario, the province of Canada account. And then charges with respect to the Lake Huron Treaty. How those charges are going to be made to the province of Canada account. So if we could go further down. And then over to the next column.
By chance, is there a compendium document?
Yes, there is.
One
160, I'm told.
Thank you. Sorry, go ahead.
The 3rd paragraph of the 15th award states that with respect to the said treaties, there shall be entered and charged in the province of Canada account against the said province as represented by the provinces of Ontario and Quebec. As of the 31st day of December, 1892, the sum of $205,000 in extinguishment forever thereafter of any claims by the Dominion of Canada on behalf of the said Indians for increased annuities under the said treaties. Which I think reflects some of the language and discussions that we have seen have taken place in 1898 and 1899 about this settlement. And then at the meeting in 1900.
Your Honor, I wondered if we could take the break now. So we'll be going into another stretch of evidence on
And what,
completing this and on to the next area.
all right, and how much do we have left in time, do you think?
I only have, I think 9 more slides and then the discussion about those slides. So I expect it would probably, subject to questions, maybe about an hour-ish.
Thank you. All right, we'll take the break. Stay.
For recess for 15 minutes. Board members, you may be seated.
We were on slide 119 before we took the break. And
Yes.
Your Honor, I believe that in an effort to help, we had different tab numbers provided than what we should have identified the extract on slide 119. It should be tab 164
Thank you.
of your demonstratives.
So I think we can go on to slide 120 now.
Before we move on to the next topic though, Ms. Jones, I wanted to ask you a couple of questions about the award.
Yes.
And in particular about the historical record that you reviewed prior to the award you've included here. And
Yes.
I wanted to ask you specifically, based on your review of the historical record, what was your understanding with respect to the party's intention for the finality of the issues related to the Robinson treaties and the debt chargeable to the province of Canada account?
To me, the language of this award, and not just the language of the award, but all of the other documentation that we've reviewed in the negotiations and the lead up to the award in, say, 1898 and 1899, indicates to me that the intent of Ontario was to secure some kind of final settlement as against the Dominion of Canada for these Robinson Treaty claims. There are so many references in the record, particularly related to Ontario, which emphasize the importance of having a final and conclusive settlement. The without prejudice language that is included not in the 15th award, I might say, but in some of the other documentation appears to me to relate to issues that are not related to the Robinson treaties. That the items that were contained in the accounts were intended to be settled in some definitive way. And I think we'll see this when we discuss the 16th and 17th awards.
You've referenced it appeared to be Ontario's intention based on the documents where you reviewed. What about the other parties, Canada and the province of Quebec?
We have less direct evidence about the province of Quebec, but again, if they, in the instances where the province of Quebec did request that there be without prejudice language incorporated in, say, an order of the board, their concerns were not related to the agreement which Canada and Ontario had reached on the Robinson treaties. They were considering other issues that were before them at the time, and their Quebec's concern was that consent to this item regarding the Robinson and Superior treaties not be construed as consent that might affect other items in the account, so that we're still under discussion and in some cases under litigation. As far as Canada is concerned, again, I think their primary concern at this time was to, I might say, protect their jurisdiction over matters related to Indian affairs, in particular Ontario's requests to have a role in managing the pay lists in the Robinson Treaty area. If Ontario were to be paying a part of the annuities at that time.
When you use to protect the jurisdiction over matters, then you went in particular Ontario's request. Do you mean to say, or are you saying to protect their jurisdiction from Ontario?
Yes.
Thank you.
Canada felt that it was vulnerable, possibly on the point of the pay lists, vulnerable in the sense that it had developed a series of practices and policies regarding the Robinson Treaty pay lists that an outside party interested in reducing the number of people paid could challenge that under existing Indian Act legislation, for example. And Canada very much did not want a process that would allow Ontario to challenge the way those pay lists had been developed and managed over the last 50 years. But also clearly felt, again, that if Ontario was paying a part of the annuities, that Ontario's claim to be involved in the amount that was going to be paid had some power, had some validity. But in order to protect its management of these pay lists, it was willing to make some sacrifices to reach a settlement to which Ontario could agree, a dollar value settlement, without allowing Ontario to go in and say, reduce the number of people considered to be eligible for Robinson Treaty payments.
Are you saying that they are willing to make sacrifices about how much money
Yes,
they were going to get without sacrificing their position on the list?
yes.
Thank you.
Ms. Jones, during the examination of Professor Mesamore, there was a discussion about the impact of this settlement or any assumption by Canada of any additional payments being a increase to the debt ceiling. Do you understand or remember that evidence?
I have seen references to that, yes.
And based on your understanding of the historical record and what you understood from Professor Mesamore's evidence, do you agree that this settlement that was reached between the parties would result in an increase to the debt ceiling?
Well, I think that, first of all, Canada has to agree to pursue a claim that would add a significant amount of debt to the province of Canada. Ontario and Quebec had expressed a position as far back as 1869 that their consent was required before Canada could add such an item. The dollar values in this particular settlement here would have it did add to the province of Canada debt, but then so did some other items that were under discussion. This was probably the largest one, the Robinson Treaty Awards. But for example, the total amount of money, say, in the Common School Fund was considerably larger than this award. And that was another issue of dispute between the parties, how the revenues and expenditures from that would be broken up. I think for Canada to make a decision to exercise its jurisdiction under 9124 in a particular way that would increase its spending in an area under its jurisdiction in Indians and lands reserved for the Indians, in my understanding, would not in itself raise a debt allowance or a debt ceiling. There's no discussion in all of the arbitrations about any of these items having an impact on the debt allowances that had been agreed to at Confederation or in 1873 or in any subsequent document. So the arbitrators themselves were not concerned about that. They did not see that as being an outcome of any of these arbitrations. So I do have some difficulty understanding that argument. There were expenditures, of course, being made under federal jurisdiction all over the country, which
I'm getting lost in the answer, possibly because I may need you to give me the background a bit on the question, or just flesh out the question a bit. You said Professor Messamore gave evidence on the impact of this settlement on any assumption of any additional payments being an increase to the debt ceiling. Could you help me out a bit?
Yes,
Just reminding me
I will
about that.
share Ms. Jones's view. I don't want to be taking as a verbatim paraphrase of what, or verbatim recollection of what Professor Messamore said, but the sense that I understood was by reaching a settlement that would result in Canada taking on any additional amounts on its own, that would essentially be an increase to the debt ceiling. So it was assuming additional debt that it was going to be bearing on its own without additional indemnification from the provinces of Ontario and Quebec. And my question to Ms. Jones.
Okay, just let me see if I have that.
Yeah.
That if Canada assumed to take on additional payments on its own, that amounted to an increase in the debt ceiling, or that resulted in?
The inference from Professor Messamore would be that that would result in an increase to the debt ceiling.
Okay.
If Canada independently assumed additional debt without recovering it from the provinces. Or sorry, assumed additional debt and did not recover it from the provinces. Yes, that's what I meant.
Okay.
If I can go back a bit, Your Honor, you'll remember that Canada had assumed all the debt
Yes.
under 111 up to the initial ceiling, which was then increased.
Forgave 62.5 million.
Assumed that without any collection against province of Ontario and Quebec.
Right.
And then it was subsequently increased in 1873.
To 72.
That's right. And as
Okay.
I understood Professor Mesamore's point during her evidences, and what I'm taking Ms. Jones to, was that any additional amounts that Canada assumed without collecting it from the provinces would be akin to an increase in the debt ceiling.
Akin to.
I think maybe those are my words, akin. She
Oh.
was indicating that it would be an impact to the debt ceiling, which would be unfair to the other provinces.
Okay. So, and you say, Ms. Jones, the dollar value of this particular settlement did add to UPC debt.
yes.
But then I'm confused when you said so did other items, but this was probably but then I thought you said the Robinson treaties were probably the largest one. Then you said, but the total amount of the common school fund was considerably larger.
Right. So that is an item which has not yet been dealt with finally by the arbitrators.
So the Robinson treaty amounts are the largest on the itemized list, the agreed list,
Yes,
and an outstanding matter. But we might be getting confused if we go to those. Outstanding matter is the common school fund, which is still bigger still.
bigger still.
But on this agreement of the agreed on items, the Robinson treaty annuities were the biggest item.
Yes, I think as I say, once we get on to the 16th and 17th awards, which are the Province of Canada account and the Province of Ontario account, you'll be able to see that the settlement, in particular, the capitalization settlement, is the biggest single contributor to the revised Province of Canada debt.
But to be clear, is it
Yeah.
your view that it has any impact to the debt ceiling as a result of the settlement?
I don't think it does.
Because of its size?
For a number of reasons. My knowing that this particular sum of money is only part of what Canada is actually spending or might spend in the future on the Robinson treaties under its jurisdiction for lands, Indians and lands reserved for the Indians in 9124. To me, spending under Canada's jurisdiction does not necessarily impact the debt allowances or the debt ceilings as among Ontario, Quebec, and the Province of Canada. And it's also, I think, noteworthy that the arbitrators did not view any of these settlements in that light. They were certainly aware of all of this legislation, all of these previous agreements, the financial arrangements, because the parties had made arguments before the arbitrators on the effect of all of these pieces of legislation and the original financial arrangements. But the arbitrators themselves did not appear to identify adding amounts to the Province of Canada debt as having any effect except for the additional chargeback to the Canada, Ontario and Quebec.
Thank you.
I think we can turn to slide 120.
The 16th and 17th awards were issued on the same day as the 15th award, and they're all interrelated. The 16th award was on the Province of Canada account. It notes the filing of a statement of this account, which is signed by Hogg, Irving, and the arbitrators. I'll explain why that is in a minute, as agreed upon by the parties, as well as the orders in council on the agreement on Robinson Treaty annuities and the agreement of the parties, that the balance of the Province of Canada account on the said 31st day of December 1892 should be apportioned, divided, and transferred to the separate accounts of the Province of Ontario and Quebec on the basis of the apportionment established by the award of the 3rd of September 1870. So this is a Province of Canada account agreed upon by the parties, and including an ascertainment of the amount by which Ontario and Quebec, as representing the Province of Canada, were conjointly liable to the Dominion of Canada. And it also set out the amounts to be charged against Ontario and Quebec in their respective accounts for the liability to Canada.
Over to 121.
Now, the last paragraph of the 16th award states that this award is made without prejudice to any claim that the Dominion of Canada may have at any time have against the provinces of Ontario and Quebec conjointly in respect of any debt or liability of the late province of Canada, not dealt with in the said statement of account. To me, that is an indication that anything that is dealt with in the statement of account is considered to be closed, finalized. That clause appears to arise from Hogg's comments at the hearing of the 2nd of June, 1900, regarding some items that were not yet entered into the account, such as this claim for a bridge. And the statement which is attached to the 16th award, again, this is the Province of Canada account, contains a line item for capitalization of annuities, $999,835, $999,835.55, charged as of the 1st of July, 1867. This is the same number that we saw capitalizing annuities in statements dating back to 1869. That covers, as we saw then, the initial $88,000, which pays for what we've come to call the fixed annuities. And then there are also entries related to the Robinson treaties charged as set out in the Orders in Council of Canada, Ontario, and Quebec, and the 15th award. So the 16th award rolls up all of these previous awards and agreements into one Province of Canada account, on which it is said there is agreement on the entries contained in that specific account.
Over to slide 122. Is this a reflection of those amounts?
Right. You can just see here what this looks like. The items, you'll notice in 1890, for example, under the heading 1890, there's an entry dated December 31, and it's identified as being 2 payments. Well, that amount, $7,728, is one of the amounts to be charged against the Province of Canada account to cover arrears in the Robinson-Huron Treaty Territory. So the payment isn't specifically identified as that, but is the same amount of money. And it's the same is true for the entry in 1891, December 31st, 2 payments, $7,864. So that's if one were looking for those particular payments in this statement, that would be where they are. But if we go down a little further,
So this is the reflection of the amounts in the 16th award.
yes,
Thank you.
in December 31st, 1892, we have an entry for Huron and Superior Indian Treaties annuities. Again, this number is drawn from a figure in the 15th award. The arrears for the Superior Indian Treaties annuities for the years specified there. $14,164. the arrears of the Huron Indian Treaties annuities for 1873. So those were ones that were not yet paid by Canada, $4,332. And then there's the capitalization number. Capitalized at 4% on an annual sum of $8,200, $205,000. And again, this is a capitalization which is described in this account as Huron and Superior Indian treaties. We've seen from some of the previous correspondence that this had initially been identified as a sum of money that would only apply to the Lake Huron Treaty because it was felt that no amount of money was necessary to capitalize Lake Superior Indian Treaty annuities. But the way it's described here makes it look like it applies to both Huron and Superior. Then below that, there's a total, $234,000. Then there's a figure for 1893, January 1st, the excess of debt to be divided between Ontario and Quebec in the proportions established by the award of the 3rd of September, 1870, and to be transferred to the separate accounts of the respective provinces. So after all this work, the excess of debt or the additional debt that is identified by the arbitrators through all of their arbitration processes is a total of $212,904.04.
Ms. Jones, the recognition of these amounts as excess debt is with respect to both the arrears prior to 1892 and the capitalized amount?
Yes. You'll see there's the reason why it's not 234 is if you look above at June 30th, 1892, there was actually a small balance at credit at that point, June 30th, 1892. So that amount at credit is then subtracted from $234,000 to produce this eventual number of $212,000.
Your Honor, the same extract is at your compendium demonstratives, tab 166.
Thank you.
Slide 123, please.
The 17th award then is the Province of Ontario account with Canada. This award states the amount by which Ontario is indebted to Canada, being the Dominion, as of the 31st of December, 1892. And it includes a charge for Ontario's share of the Robinson Treaty settlement. In fact, Ontario's share of this, what they called the excess of debt number. And it attaches a statement of the Ontario account endorsed by Hogg, Irving, and the 3 arbitrators.
Could you just tell me if the, excuse me, if the 17th award is the Province of Ontario account with Canada, what is the 16th award?
That's the Province of Canada account.
Thank you.
So
Thank you.
this is not, the 17th award then is not Ontario's whole balance sheet. It's only how they stand in respect to Canada at this time.
The Dominion.
Yes, the Dominion. Whereas the Province of Canada account is a record of the debt of the Province of Canada ascertained as of the end of December 1892. And this award, the 17th award, notes on its face that, quote, certain matters respecting the Common School Fund and the Northwest Angle Treaty Number 3 have not been fully concluded and determined. And as the principal or capital of certain funds held by the Dominion for the province have not been entered in the statement to the credit of the province, this award is and shall be taken to be made with respect only to the matters dealt with in the said statement, and without prejudice to our authority in the final statement of account, and in our award therein to add or take from the said amount, by reason of anything not concluded in the said statement of account. So they're not saying that the items in the statement are necessarily to be reopened, but there could be other things not in the statement, which might be added at some point. They give 2 examples there of issues that were recognized as being not yet settled that could later be added.
Those being,
The Common School Fund and the Northwest Angle Treaty Number 3. And as well, some of the trust funds held by the Dominion for the province were not included in the statement.
slide 124.
Now, the reason why the Province of Canada account was only signed by Ontario and Canada, the Dominion, as explained in this slide. Mr. Trenholm, Counsel for Quebec, refused to sign at the meeting of the 2nd of June, 1900, claiming he had not seen the account before, which occasioned much exasperation on the part of Ontario and Canada representatives present, but he refused to sign. But at a later meeting of the arbitrators on the 9th of May, 1901, Trenholm did sign. He endorsed both the Province of Canada account and the Province of Quebec account. So therefore, we have the 19th award, which is on the Province of Quebec account. And again, this is Quebec's account with the Dominion of Canada. As of the 31st of December, 1892. And it as well notes that certain matters, among others, that respecting the Common School Fund, have not been finally concluded and determined. And as well, Quebec had some trust funds held by the Dominion of Canada, which were not entered in the statement. So the language is in the 19th award that, quote, this award is and shall be taken to be made with respect only to the matters dealt with in the said statement and without prejudice to our authority in the final statement of account to add to or take from the said amount by reason of anything not concluded by the said statement of account.
Slide 125.
After these awards were reached, Ontario, Canada, and Quebec then update the Province of Canada, the Province of Ontario, and the Province of Quebec accounts with the Dominion of Canada up to the 31st of December, 1902. And that's in part because of some of these issues which had not yet been concluded. And in fact, by 1902, not all of them were concluded either. But they did update their accounts for up to another 10 years. On the 10th of July, 1903, the Deputy Minister of Finance then reports to the Auditor General that apart from the Common School Fund litigation between Ontario and Quebec, claims related to Treaty 3 and the Yule Bridge claim, as far as he is concerned, the Auditor General, the 31st of December, 1902 statements, quote, close the accounts as far as the Dominion is concerned. So there are no additional transactions recorded in these statements regarding the Robinson Treaty annuities or on other items that had not already been concluded.
Slide 126.
So then in August 1903, Mr. Scott, the departmental accountant, instructs the bookkeeper of the Department of Indian Affairs to make the following entries in the Indian Fund accounts. Again, we can make this a little bigger.
Your Honor, this is at your compendium of demonstratives, tab 173.
Thank you.
This little extract here from the instructions to the bookkeeper is just to indicate how these credits were made. And you'll notice that there's two types of accounts here, capital and interest. Capital accounts are for the generation of interest revenue and are not actually available for immediate disbursement. Interest accounts, however, can be dispersed. So the amounts as ascertained in the awards for arrears of annuities, things that should have been paid to the Indians prior to 1875, but were not, were placed in these accounts called interest. They're not actually interest, but they can be dispersed if they're placed in accounts labeled interest. So that's explains that part of it. Now, the capital account is kind of interesting in that this represents the sum of $205,000 charged in the Province of Canada account, as Mr. Scott says, to meet the full obligations of the province, meaning the Province of Canada, under the Robinson treaties. But we've seen that the 205,000 was at one time anyway, apparently only intended to cover people in the Robinson Huron Treaty area and explicitly not to cover people in the Lake Superior area.
It was only calculated on the basis of Huron numbers.
Right. But the way we see this allocated here is that 205,000 is divided between the capital accounts of the Lake Huron people and the Lake Superior people. The proportion is the same as the proportion in which the fixed annuities are referred to in the treaty. Mr. Scott doesn't say that, but if you do the math, it's the same proportion as the 600 pounds and 500 pounds were in the treaty itself.
Ms. Jones, was this division of the capitalized amount done at the direction of the award of the arbitrators or at the direction or request of the provinces, Quebec and Ontario?
I haven't been able to ascertain anywhere why Scott did this the way he did it. I haven't been able to trace that anywhere. He was the one, after all, who had written the memoranda to say that, in his opinion, there need not be any capital provision for the people in the Robinson Superior area, and that capitalization would apply only to the Robinson Huron people. So I don't know why he has done this the way he's done it.
Was he did you say the treasurer?
The accountant of the Department of Indian Affairs, chief accountant.
Slide 127, please.
Now, in 127, I've made this point. Some of the things I've just talked about capital and interest accounts and the total capitalization being divided. The Department of Indian Affairs paid out per capita distribution for arrears of annuity for 1874 and earlier. These payments were made in 1903, spilling over into 1904. At the rate of $9 per person in the Robinson Superior Treaty and $3 per person in the Robinson Huron Treaty, because there were fewer years prior to 1875 identified in the Robinson Huron Treaty area by the statements where there was a sufficient excess of revenues over expenditures. So that's why their payment looks so small compared even to their colleagues in the Robinson Superior Treaty. And just again, to get a sense of the actual fact situation for the Department of Indian Affairs, in 1903, a total of 5,218 people were paid these arrears in both treaty areas. And we have just seen that Canada has made a settlement as far as capitalization goes for about 2,600 people.
So aside from the arrears payment, does that result in a $4 payment per person?
Well, the capital fund wouldn't be enough to make $4 payments to even the people in the Robinson Huron Treaty area, let alone the people in both treaty areas. It would be quite a bit less than that.
So the capitalization based on 2,600 people was for both?
Well-
Or was it only for the Hurons,
It seems to have initially been intended only for the Hurons,
right?
but then somewhere maybe around the middle of 1899, the capitalization amount seems to be referred to as affecting both treaties.
And that gap happens
Yeah.
somehow near the end of the negotiations.
Yes.
Or that difference.
And in the end, in the implementation, the Department of Indian Affairs divides up the money.
Mr.
Yeah,
Shepard-Sonsky?
just a point of clarification, perhaps the witness can clarify it. I believe there was a discussion about the estimates being made on 2,600 people. I think the prior evidence was it was 2,800 people.
2,800 then reduced to 2,650.
Right.
The 2,650 was the final settlement
Yes,
with Ontario. 28 was Scott's last
Okay.
right.
proposal to council. I think. If I recall correctly.
Yes, that's right.
And just to make sure I don't get lost in numbers, even at the reduced number that was determined to be appropriate for the settlement, that didn't allow for a $4 payment per person.
No, it
based on
didn't.
actual numbers.
No. The amount for arrears, again, was calculated on these, what Hogg himself called arbitrary numbers. We are going to assume that this many people should have been paid arrears prior to 1874. We've seen a little bit of insight into what that process looked like. So again, even the amount that the Dominion claimed for past payments that it had already made or made before 1874 were based on estimates, averages, what was considered
Thank you.
acceptable as an offer to Ontario and Quebec, what Ontario and Quebec can be asked to pay. So they're not precise numbers based on the actual number of people on the Robinson Treaty pay lists, even prior to McRae's revisions of the pay lists, or afterwards for that matter, because we can see that in 1903, Canada is paying 5,218 people.
Your response to Honor's question a couple moments ago about the gap in the intention to reach a settlement for Robinson Huron only versus what the result was with the settlement. Can you clarify, please, whether it was a gap or the intention of the parties to settle it for both parties?
I think the language, it's the letter of Hogg of the 25th of August, where he refers to a settlement affecting the Robinson Huron and Robinson Superior treaties. But whether he really means that capitalization is to be applied to both, or whether he means just this is a number that we've agreed on for the Robinson Huron people. And as the Robinson Superior number in our estimation is 0, that would cover everybody. Or whether there was any intention to ever divide this capitalized number. I can't see that there was an explicit expression of intention to divide the capitalized amount between the Robinson Huron and Robinson Superior accounts. But this is the way that Scott has done it in 1903. And I haven't been able to unravel any particular justification or explanation that he may have made at some point for why he did that.
I don't mean to belabor the point, but just to make sure we're being clear, aside from,
Try not to leave too much more.
yes, aside from the question about why the decision was made to pay both communities, I'm asking about what is your understanding about the intention to settle for both communities independent of how the payments would work?
The language that's used repeatedly in the negotiations on this settlement indicates to me that the intention was to negotiate a settlement that would cover all outstanding claims related to the Robinson treaties of the Dominion against the old province of Canada, and therefore against Ontario and Quebec.
And do you have your answer?
I do.
All right, and can I see if I've got it right? You started one of your answers by saying the number looked initially. Now I'm asking you to confirm if I've understood this correctly. That number, whatever it is, 205,000, I think. That number looked initially, or sorry, that number initially was described as only the capitalization of future payments for the Huron Treaty.
Yes.
But somewhere in the correspondence and the awards and then the implementation, the capitalization amount was applied to both Hurons and Superiors.
Yes.
And then you said just before your last answer, if I have that correctly, but with respect to intention of the parties, you don't see an articulation of a change from what was in Hogg's letter of August 25th. Like that's the last,
Right.
last
I don't
articulation of an intention.
Yes, I don't see any articulation in 1899 or 1900 of an intent to divide that capitalization amount between the Robinson Superior and the Robinson Huron treaty accounts. Again,
When you use the word divide though, do you mean apply it? Or I'm not sure what is going on because it's not, they're not actually taking that 205 and splitting it into something and paying it out. They're capitalizing it
Right.
to reflect their, as Ms. Glasser is trying to ask, their intention to satisfy their, their intention to set aside an amount that will generate interest
right,
to fulfill their obligations.
right.
But we already know from the Dominion's point of view that it's never going to satisfy what they're actually doing.
Right.
So what they start out by saying is, if I get this correctly, that we in the department see that there will be future increases necessary, or that there will be future payments up to $4 in the Huron territory. But we don't foresee such increases at this time or in the near future for the superiors. So let's just take, if I understand correctly, let's just take the Huron numbers. And when we get to those numbers of, I don't know what it is, $8,200 per year, they come up with the amount $205,000 is necessary to set aside to generate 8,200, which is what they foresee as the annuities that will be payable to the Hurons.
Or at least a part.
A part of
they're
what will
going
be-
to be paying.
And they bargain, they start bargaining at that point, and all possible logic goes out the window. Because they're not actually bargaining on the basis of a number that they know they're paying.
Right.
That's the first thing. They're not revealing the number, the actual number, or maybe Ontario has a sense of a number, which is why they're challenging it. But Ontario is ready to make a deal on a number that's fictitious. Sorry, who is? The Dominion
Yes.
is prepared to make a deal on a number of annuitants that is fictitious. But it was, the calculation was only ever done on Huron numbers. And now, when it comes to implementation, they just take that number, which is not rooted in reality, and they apply it to two different territories. But they don't explain why.
That's correct. That's the
caught on
way
that?
I see this happening. Yes.
Okay. If I've really upset your
Nope.
game, Ms. Glassman, I'm sorry, but I was trying to follow.
I think we finished slide 127. We can go to slide 128.
So after these payments have been made in 1903, there is a Supreme Court decision on what has happened, the backstory to the Supreme Court decision. Canada has been holding trust funds for both Ontario and Quebec. Some of these are the same trust funds as were mentioned in the fourth schedule to the British North America Act. But the Dominion is still holding them and paying out interest every year or twice a year to Ontario and Quebec on these trust funds. They have been paying 5%, which is the rate of interest that's mentioned in the British North America Act. But as the actual market rate of interest by the early 1900s is so much lower, it's more like 3%. Canada announces to the provinces, we're only going to be paying you 3% from now on. Canada and Ontario then, or Quebec and Ontario then take Canada to court to say, we had a deal. You're going to pay us 5% on these trust funds. This issue went to the Supreme Court and was decided in 1907 that in fact, Canada could pay a lower rate of interest to Ontario and Quebec on these trust funds. So that left all parties then paying the same rate of interest to each other on the trust funds and on Ontario's outstanding liability to Canada, which meant that Ontario was no longer making any money by having Canada hold on to its trust funds for it. So Ontario's liability to Canada at this time included the $112,350.53 that was its share of the province of Canada debt as ascertained by the 16th and 17th awards. The proposal then from Canada and Ontario was that as the amount in the trust funds and the amount of the outstanding debt were so close, in the words of their agreement, that say they agree there is no advantage in carrying the accounts further. And this was a decision that was approved by Canada's finance minister. So in other words, both parties at this time are ready to just cash out and call it a day on keeping these accounts and paying this interest on the trust funds and on the outstanding debt. So on the 21st of September, 1906, or 1908, I should say, Canada issues a check to Ontario for $172,000, $172,654.92, which is the difference between the amount Canada is holding in the trust funds and Ontario's outstanding debt to Canada, as it was stated in the public accounts of Canada in the 31st of March, 1908. So this outstanding debt to Canada does include other items as well as its share of the province of Canada debt, but it does include its share of the old province of Canada debt. So Canada issues this check for the difference, and the balance was deposited in the Consolidated Revenue Fund of Ontario in that fiscal year.
Final slide. 129.
We come limping to the end.
Triumphant. but limping.
Well, so there is one more award of the Board of Arbitrators, the 20th award, which is on the Common School Fund. There had been several previous awards also on this fund. The 20th award is on yet another aspect of the Common School Fund. It was issued on the 6th of January, 1908. As I note here, the arbitrators die off gradually, one by one. So there are no people left on the Board of Arbitration. And when the secretary to the board, Mr. Odette, who you may have seen his name on some of the documents, was elevated to the bench in 1914, he offered the board's papers in his possession to the National Archives, now known as Library and Archives Canada. But the assistant treasurer of Quebec wrote to Mr. Odette saying that he thought maybe some final award should be made. And it's not clear what this award might be, but and neither was Mr. Odette very clear on what it might be, but it seemed to be some kind of a wrap up or a declaration that the process was over, was possibly what the treasurer of Quebec had in mind. But anyway, by 1918, Mr. Odette had had enough of waiting and sent all the papers and documents in connection with the arbitration, which is now at an end, to the National Archives for safekeeping. Those papers are now at Library and Archives Canada, and in fact, we've seen some of them. That seems to be the end of the arbitration process.
Thank you, Ms. Jones. Your Honor, may I have just 2 minutes, please?
Yes, please. Take it.
Your Honor, that concludes the examination in chief of Miss Jones. I do have some documents that we identified. I believe it was on Monday or Tuesday at the start of the examination during her questions, so they're not new documents. I just didn't have the copies for you. And so I've made those copies and I've identified them with the slide number and everything, so you're able to refer to those.
Okay. And I also have a question about documents that you brought up. I don't remember the time, but it's a document that you referenced, and it's exhibit 1-1770. It's the letter from Hogg to April 10th, 1899. Is that to be marked in any way, or where does it go with a slide or
Yes,
with
it
a?
does. If I could have one moment, I can find that.
All right.
Just on these new documents that my friend is handing up, can we get copies to see what they are?
Right.
Yes,
Thank you.
And I have the April 10th, 1899. It's trial exhibit 1-1770
Yes.
already.
But what was the slide number? I didn't make a note.
Oh, I apologize.
Thank you.
the document JBD 1770 was from slide 108,
Slide 108, thank you.
relevant to the third bullet.
And before you name anything or identify it, please make sure that your colleagues have it. And if it needs wait till Monday, we can do that too.
Which you have indicated 2 meetings, these are all already trial documents. So it looks like one of the 3 has the exhibit number. Are you able to identify the exhibit numbers on the other 2?
Thank you for the indulgence, Your Honor. These documents are not new items in terms of being outside the JBD. They are within the JBD for stage 3 or stage 1.
Yes.
And I've marked them each one. I'll give a copy to registrar so I can read them out. So the first document that is a darker shaded handwritten letter that says stage 3, exhibit 1, tab 2817,
Yes.
slide 62. That is the Dawson letter that we looked at from 1873.
Yes.
Thank you.
And the slide is referenced on the front of the document.
Slide 62.
Yes.
Thank you.
And this next document, it refers to New Indian Annuities Upper Canada. Is from JBD stage 3, 1754. From Miss Jones, slide demonstratives 54.
Thank you.
And the final document with the white cover page says it's from JBD for stage 1, 067, slide 46. And this one is the order in council regarding the Robinson instructions to Mr. Robinson for the Robinson annuities.
And did you hand that up? Oh, nice. Yes. Thank you. I've got all 3.
And Your Honor, before we complete our case, Madam Ms. Gaggy has a read-in for the court, and I wonder if we should exclude the witness.
I just have one more question then.
Yes.
Exhibit 96, I have as letter dated June 13th, June 12th, 1898. And it was from footnote 332. I presume that's of Ms. Jones' report.
Yes.
And then I have a notation in someone's name, and I'm not sure, MAGE 0122 and 5925.
That likely would have been the document number.
Do I need that? Or just footnote 332?
That's right.
Thank you. Okay. Ms. Jones, for today.
Thank you.
We'll see you back here Monday at 10, please.
Monday.
Yes. And when you say this is a read-in of documents, do you want to do this at after the cross-examination?
Whatever you'd like, Your Honor, we could do it today. We can do it, a reading of interrogatories.
Okay,
So
it
if,
seems short.
yeah, it is. It's just one question before we forget. So if we can have this exhibit, this document marked as an exhibit, it's entitled Responses to Ontario's Questions on Written Examination for Discovery, and it's dated September 9, 2016.
Yes. I was just looking at a team.
Different team today.
Okay, go ahead.
Question number 10, please confirm that once responsibility for the excess liabilities of the province of Canada was divided as between Ontario and Quebec, the resulting ratio was not changed as a result of the subsequent identification of quantification of particular pre-Confederation liabilities. Answer confirmed. That was easy.
Okay.
And we've provided advance notice to our friends of this document and also shared it in the opening statement.
Thank you. So is it an exhibit?
Yes,
Numbered exhibit?
yes.
Okay, that'd be 98.
Okay, so we're done for the day, Ontario. Okay. Very good. Anything else we can reasonably do today?
I'd just like to extend the invitation from the fire keepers and knowledge keepers that we will be having the evidence portion of the trial, sunrise ceremony at 6 a.m. on Monday.
Thank you. All right. And after the sunrise ceremony, we will convene at 10. We will have cross-examinations followed by a case management conference. Very good. Thank
All rise.
you.
Oh yay, oh yay, oh yay. The sittings of this court have now concluded. Long live the king.